Greetings and welcome to the Montana Land and Water Alliance discussion of the water settlement between the state of Montana, the Confederated Salish and Kootenai tribes, and the United States. The Alliance understands that this settlement represents just part of a huge storm brewing over the western United States. This storm involves a fundamental structural policy change in the balance between state and federal government control over state natural resources, especially water. This storm at its core represents an attack on private property rights, the rights of citizens, and the institutions which support those rights. The tools used to promote this structural change and assault on property rights include excessive environmental regulations and directives, the Endangered Species Act, and now, Indian water settlements. The combined use of these tools represents a perfect storm, which now is burning through the western United States. This discussion is about the Indian Water Settlement Tool, and Montana is ground zero for its development because this Indian water settlement is like no other in the United States. The application of this CSKT Compact's principles has serious implications for the western states. The Montana Land and Water Alliance was formed to protect property rights in Montana and in specific response to the CSKT Compact legislation. Protection of property rights is indeed one of the reasons for which government is formed. As Madison says, in a word, as a man is said to have a right to his property, he may be equally said to have a property in his rights. These are two elements which relate to property rights protection. The contrast of this statement with the grand bargain, which is the key portion of the CSKT Compact, is stunning. The response is to remind the tribes about the grand bargain and the fact that we agreed to do this extraordinary thing, frankly, with respect to agreeing to subject or to remove non-Indian rights on the reservation from the jurisdiction and control of the state, and place that somewhere else at the tribe's request. In the CSKT Compact, not only is there a taking of rights to property, but there is a taking of the property to basic constitutionally protected rights of citizens. In brief, here is an overview of our presentation. First, we will discuss the quantification of Federal Reserve rights and the two pathways we see evident in this compact. Next, a historical setting and context of the reservation. We will then discuss the compact and the state and federal issues raised in the compact. Finally, we will summarize and conclude the presentation with basically the perfect storm, a call to action, and its implications for the western United States. In the quantification of Federal Reserve rights, there is a standard pathway that is most often traveled, and then there is a dangerous new road that was created by the CSKT Compact. In the general standard way, the foundational principles start with a federal reservation of land. The mechanisms and laws used to quantify the amount of water for that federal reservation include the historic and legal context of the federal reservation, and thus used to determine the purpose of the reservation and therefore the quantity of water necessary to fulfill that purpose. The priority date of the water rights for these reservations is the date of the federal reservation. The end result is a specific quantity of a federal reserved water right is determined. There is certainty for all water users, state and federal and tribal, and the state retains jurisdiction and control of state waters and citizens, and the U.S. or tribe retains jurisdiction over its water resources via a tribal water code. The dangerous new pathway created by the CSKT Compact starts with a foundational principle of a tribal reservation of land. The compact then goes on to ignore the legal historical context, the definition of the reservation, and the treaty cession of land. The purpose of the reservation and ceded lands is determined to be a homeland, and all water is reserved by the tribe to fulfill the purposes of a homeland. The priority date for the water right is time immemorial. The end result of the CSKT compact is an unlimited quantity of a water right, no certainty and/or condemnation of existing water rights. The state cedes jurisdiction over state waters and citizens to the tribe and the United States, who then take jurisdiction over all waters on the reservation and off the reservation, whether derived from federal, state, or tribal law. Let's describe the setting and context for our discussion today. First, we will discuss the current land status, and then discuss the historical context and development of the reservation, the water development infrastructure, and the federal and state policy framework. Currently, the Flathead Indian Reservation consists of 1.3 million acres in portions of Lake, Sanders, Missoula, and Flathead counties. 28,000 people live within the exterior boundaries of the reservation, of which approximately 5,000 are tribal members. Currently, 52% of the reservation land base, shown in the green shaded areas, are lands belonging to the United States in trust for the CSKT, and consist of the mountain ranges and hills within the reservation. The light yellow areas are non-Indian owned, fee-titled private lands, and comprise about 48% of the reservation. As you can see, they are organized as literally an island of private property within the exterior boundaries of the reservation. These maps compare the land status of the Flathead Indian Reservation in 1910 and currently as of 2015. Reviewing these two maps, we find the following. In 1910, all of the best agricultural land was allotted to the individual Indians and Indian families and is shown in orange. The physical infrastructure for irrigation was developed close to the mountains to capture runoff on all sides of the reservation. The lands shown in gray are state lands, according to the map, but they actually represent the surplus unallotted land that would be sold to the settlers under Article 6 of the Hellgate Treaty, the 1904 Flathead Allotment Act and its 1908 amendment, and the presidential opening of the reservation in 1909. By 1924, most of the Indian lands in orange had been sold by individual Indians and Indian families to the settlers, such that within the irrigation project, 80% of that land was owned by non-Indians, with 20% in ownership by individual Indians or Indian families. Between 1910 and 1924, the tribes had effectively walked away from agriculture. In 2015, we see that there is an island of private property within the exterior boundaries of the Flathead Indian Reservation, with some original Indian allotted lands remaining and shown in orange. With the irrigation project, 90% of the lands are owned by non-Indians and 10% by Indians, not much different than the land status in 1924. The water rights associated with the 1910 lands shown in orange then became the Walton rights belonging to private lands in 2015. Walton rights are those water rights associated with an original Indian allotment that were sold to successors or is owned by successors in interest. Three important questions arise when looking at these land status maps. First, if the United States developed water resources to fulfill the purpose of the reservation, which was agriculture, and allotted lands to the Indians, when the tribes walked away from agriculture, did they also abandon their federal reserved water rights? Second, why was the existence and significance of the Walton rights ignored in the compact settlement discussions? And third, similarly, Why were the individual Indian Alati water rights also ignored in the compact settlement? The historic framework and context begins with the Treaty of Hellgate, and in particular a few key articles. As we look at what the treaty said, we can then see that the compact has actually reinterpreted these key articles of the treaty. Article 1 of the treaty describes how the tribes ceded all right, title, and interest to its aboriginal lands to the United States. The first recital of the compact, however, reinterprets this language to claim that they never gave up all rights, title, and interest to those lands. The United States, through the Indian Claims Commission, paid the tribes for these ceded lands, and as a practical matter, the Indian title, rights, and interests have actually been extinguished. Article 2 establishes that the United States reserved the Flathead Indian Reservation out of the lands so ceded. Note that in the compact, the tribes claim that they, not the United States, reserved their own reservation. Article 3 is common to all Stevens Treaty tribes, and the article secures permanent access to ceded Aboriginal territory to the tribes in common with the citizens of the territory. The access was secured for taking fish, hunting, and gathering. Article 3 also provided the tribes with the exclusive right on the reservation to hunt and fish. The compact reinterprets Article 3 to determine that the access right became a water right with a time immemorial priority date. This is the new water right created by the compact's flawed assumption of a tribal reservation of land for a homeland purpose. On reservation, the compact reinterprets Article 3 to transfer 90% of the existing private water rights developed in the Flathead Irrigation Project to the CSKT for use as in-stream flow. Article 6 of the Treaty of Hellgate references Article 6 of the Omaha Treaty, in which the United States intended to allot lands to individual Indians and families, and to dispose of or sell all the surplus lands remaining after this allotment pursuant to the United States. However, the compact's definition of the Flathead Indian Reservation ignores Article 6 of the treaty and claims all lands belong to the tribes regardless of land status, rights of way, and historic development. This is a map of Montana that shows the resulting configuration of the Flathead Indian Reservation subsequent to the Hellgate Treaty. It also shows the other treaty areas of the several tribes in Montana. Of note is the following. The yellow area shown in western Montana, outlined by a green line, shows the ceded Aboriginal lands of the CSKT. The Flathead Indian Reservation is shown in the pink area within the Aboriginal lands and is highlighted by the purple line. Notice the gray area shown on your left and highlighted by the blue arrow consists of Aboriginal lands not belonging to the CSKT. However, the compact improperly extends the CSKT water rights into this non-CSKT ceded area. The red outlined area purports to show the CSKT subsistence range. This subsistence range is not acknowledged in the Treaty of Hellgate, and case law describing the interpretation of Article 3 of the treaty indicates that access is only provided to the ceded Aboriginal territory, shown in yellow. The sky blue area outlined represents lands within the 1855 Judith River Treaty. Article 5 of that treaty excludes the CSKT from this area. However, because the compact's reinterpretation of Articles 1, 2, and 3 of the treaty and inclusion of its subsistence area, tribal water rights are claimed in over two-thirds of Montana, including the non-CSKT ceded lands of the so-called subsistence range. The consequences of the tribe's radical reinterpretation of the Treaty of Hellgate leads to this map showing the extensive water claims filed by the CSKT in the Montana General Stream Adjudication. These claims extend outside the reservation, ceded territory, and extend into eastern Montana. These are likely to be litigated with or without the compact's approval by Congress, as these claims are not dismissed completely even if the compact is approved by Congress. The federal and state legal framework that results in the land status of the reservation today, a description of what it produced, and the compact reinterpretation is shown in this table. Beyond the Treaty of Hellgate, federal laws and statutes determine the land allocation and water development infrastructure for the reservation. As is typical of many Indian reservations, a federal irrigation project was developed, which in the case of the Flathead was designed to serve the Indians and the settlers. The compact reinterprets these federal statutes to mean that the irrigation project and all water development was designed to serve only the CSKT. The Indian Reorganization Act of 1934 stopped the allotment process and restored to tribal ownership the surplus lands that had not been allotted or homesteaded, and protected existing patented fee-titled privately owned lands. In the CSKT Compact, the definition of the reservation ignores the private ownership of land and takes water rights associated with those lands, completely ignoring the Indian Reorganization Act's protective clauses. The federal policy framework for resolution of the federal reserved rights includes, first of all, state control over non-navigable streams through the Desert Land Act of 1877, the Winans decision of 1904 interpreting Article 3 as an access right to ceded Aboriginal lands. The Compact interpreted the Winans access right to mean a water right. The Winters decision describes the existence of federal reserved rights. The Compact reinterprets Winters to mean all water on the reservation was reserved to fulfill the purposes of the treaty, and off-reservation water rights exist to fulfill the purposes of the treaty. The Reclamation Act determined the development of water resources on the reservation. The Compact reinterprets the Reclamation Act to mean that all water development was done for the tribes alone. The Indian Reorganization Act stopped the allotment of land and restored to tribal ownership the unallotted surplus lands on the reservation. The McCarran Amendment specifies that federal reserved rights can be adjudicated in state courts. The state framework for resolving federal reserved rights include the state constitution, the McCarran Amendment, the Montana Water Use Act, and the Compact Commission. The Compact rejects all of the components of the Montana Water Use Act and seeks to claim all water in tribal ownership regardless of state courts and procedures. The Compact Commission ignored its legislative mandate and assumes it can create new federal water rights and then negotiate all water rights, not just the reservation-specific federal reserved rights. The infrastructure for water development was primarily developed by the federal government with the intent to serve all. In general, the Compact rejects this state and federal policy framework, concluding that all water infrastructure development was undertaken on behalf of the tribes. In summary, then, the standard framework for the quantification of federal reserved rights on Indian reservations, including the federal reservation of land, allotment, and case law interpreting Article 3, case law determining the procedures for measuring and quantifying a federal reserved water right, and the legal framework for negotiation or litigation of these rights, is rejected by the CSKT Compact. Instead, the tribe requires all of the water flowing through, over, and under the reservation, off-reservation water rights, time immemorial priority dates, administrative authority over all water rights, whether derived from state, federal, or tribal law. Montana's cession of these standards in the compact meant that each of these tenets had to be rejected, and this is where the false narrative began, including citizens being told that they never had water rights in the first place, treating them as squatters on the tribe's rights. Let's turn our attention now to the CSKT Compact. It has a number of flawed assumptions which have impacts on citizens. We'd like to discuss the Unitary Management Ordinance and the Montana Constitution, again the state questions and federal questions, and then conclude with the logical conclusions of the CSKT Compact. This slide shows the Compact's flawed assumptions contained in the first 8 pages of the Compact. These assumptions set the framework for the entire 1,500-page CSKT Compact. The very first recital sets the stage for the claim of all the water by stating, erroneously, that the tribe reserved the Flathead Indian Reservation, not the federal government. This is simply false. However, the consequences of this assertion is that the CSKT own all the resources, land, water, timber, air, etc., within the reservation exclusively. In the next recital, the CSKT claim all sorts of new federal water rights as an extension of the first claim, transform an access right into a water right, expand federal reserved rights beyond the purpose of the reservation and reservation boundaries, and, as an extension of the first and second recitals, claim sole administrative authority over all water rights, whether derived from federal, state, or tribal law. Finally, the Compact adopts a definition of the reservation as Indian country, instead of Montana's definition of Indian land. The tribe's definition includes all land within the exterior boundaries of the reservation, independent of existing land ownership status and independent of the strictures of the Hellgate Treaty and Montana's definition of reservation land. Thus, land patents, existing rights-of-way, and water rights are not recognized. The amazing part is that the state of Montana accepted each of these flawed assumptions. Once the state accepted these premises, it became the basis for the abandonment of state citizens, due process, the Montana Constitution, and property rights. While not a complete list of compact concerns, this chart represents some of the major consequences of the proposed CSKT Compact that affect state law, the Montana Constitution, and the rights of Montana citizens. The Unitary Management Ordinance removes tax-paying citizens from the protection of state constitution and laws for water administration and places them elsewhere. It establishes a new quasi-sovereign entity, neither federal, state, or tribal, with no accountability. It provides for the political appointment of members to a water management board with inordinate representation of the tribe, and no conditions on the removal or of term limits for board members. It diminishes the due process of state citizens with likely bypass of state courts in favor of a court of competent jurisdiction. The state consents on behalf of its citizens to place them under a different jurisdiction. Agricultural water and other property takings result from the taking of the project water rights and transferring bare legal title to the CSKT, and allowing 90% of the irrigation water to be transferred to in-stream flows. The irrigation water right is replaced by a certificate to use water, and results in year-to-year uncertainty, compromising the ability of farmers and ranchers to get financial support from banks for yearly operations. These are blatant takings of valuable property rights without compensation. The taking diminishes citizenship, due process, and representation of state citizens who are 100% subject to state taxation. These takings diminish property values and agricultural productivity. Claims for water rights over 2/3 of the state of Montana cloud titles and result in disclaimers on title insurance and deeds and affect property values. Now let's look at the constitutional violations in the CSKT Compact, which arise primarily through the creation of the Unitary Management Ordinance, or the Law of Administration of the Compact. The Montana Constitution, Article 2, is the Declaration of Rights of Citizens, and the constitutional violation involves equal protection, due process, immunity from lawsuit, a citizen right to trial by jury, and the takings provision. Article 3 involves general government, and the UMO violates the separation of powers. Article 5 involves the legislature, and the Unitary Management Ordinance creates a special or local law to apply to a limited number of people within the state of Montana and ignores the general law or the Montana Water Use Act. Article 5 is the judiciary. The UMO violates this article by removing the Montana District and Supreme Courts from availability to citizens to resolve disputes. Article 9, which is Environment and Natural Resources, is violated because the compact refuses to recognize all pre-1973 water rights. And next, that the state constitutionally derived control, ownership, and administration of water resources is delegated to the CSKT. Remarkably, Montana's Legislative Services Division, the Attorney General, and the Governor, all trained attorneys, refused to see any of these issues in the Constitution or in the Compact as violating the Constitution and supported it. Recalling the two pathways for resolving Indian water rights, the CSKT Compact produces an entirely different result than all of the other compacts in Montana, as shown by this table. All of the other compacts assume the federal reservation of land, the quantification of federal reserve rights to fulfill the purposes of the reservation, and did not claim water off the reservation. State jurisdiction over state water resources and citizens was retained. The volume of water claimed by the tribes in this chart is consistent with these standard tenets. The Flathead Compact, however, results in vastly different water award and geographical extent of that award. Just 3 claims in the CSKT Compact result in 27 million acre-feet, vastly exceeding the 1 million acre-feet awarded to the Fort Peck Reservation. Comparing the CSKT Compact with other tribal negotiated or litigated water awards in the United States also indicates how different the CSKT Compact is. Just 3 claims in the CSKT Compact represent 4 times as much water as awarded to the combined total of 27 tribes. The state questions raised by the flawed assumptions of the Compact are significant and can be organized into 2 categories. The first category involves questions related to the process and results of negotiation of Federal Reserve water rights belonging to an Indian reservation. These include Can the state rewrite or reinterpret a treaty? Can a state take an appropriated beneficial use water right belonging to a federal irrigation project and transfer the bare legal title from the project users to the United States in trust for a single beneficiary, the tribe, and without compensation? Can the state turn a federal treaty access right into a federal water right on off-reservation ceded lands? Can a state create new federal water rights? Can an Indian water settlement or a state reject, reverse, and violate federal public land laws, including the Homestead Acts, Reclamation Act, and other federal land laws developing western states without Congress and without compensation? The second set of questions involve the constitutional and jurisdictional questions raised. Can the state diminish the constitutional rights of equal protection, due process, and representation of its citizens on private fee-titled lands within the boundaries of an Indian reservation? Can a state delegate its constitutionally mandated authority for the ownership and administration of state water resources to a politically appointed, tribal-dominated board with no accountability? The CSKT Compact flawed assumptions also raise a number of federal questions. These can be organized into two categories. First, what is possible in a negotiation or litigation of an Indian water right? And secondly, constitutional and jurisdictional questions raised by this compact. Under negotiation or litigation of Indian water rights, did the United States reserve Indian reservations, or did the tribe? If the latter, does any federal law apply? Can an agency of the United States reinterpret or renegotiate the Treaty of Hellgate without Congress knowing that by ratifying the compact they will be rewriting history and voiding existing federal law? Can an agency of the United States reinterpret, rewrite, or reinterpret the Indian Reorganization Act without Congress knowing that by approving legislation it is violating its own laws? Can an agency of the United States reject federal land laws, responsibilities, or contractual obligations with water users in a federal irrigation project without compensation? Can an agency of the United States expand or create a new type of federal water right known as an Indian or Aboriginal reserved right on or outside the reservation in violation of existing laws? And can an agency of the United States transform an access right into a water right without changing or violating the original intent of a congressionally ratified treaty and associated case law? Under the constitutional and jurisdictional questions, can an agency of the United States expand federal or tribal jurisdiction over non-tribal members and non-Indians, effectively creating a non-republican form of government over its citizens? Can an agency of the United States force a state to violate its own constitution in order to meet a federal obligation? The logical conclusions of the CSKT Compact. If we were to summarize succinctly what this compact did, we would say that the parties to the compact refused to recognize the legal diminishment of the Flathead Indian Reservation as a result of Article 6 of the treaty, allotment, and the opening of the reservation in 1909. In doing so, the compact necessarily diminishes and violates the constitutional protections and rights of Montana citizens. This was done through the rewrite of the Treaty of Hellgate, the Indian Reorganization Act, and other congressional acts, by creation of new and expansion of existing federal water rights, by changing the federal-state relationship regarding citizens, lands, and water, and by setting precedent for the expansion of federal water rights claims across the West and the unlawful condemnation of existing vested water rights. The CSKT Compact and a Call to Action. The CSKT Compact represents a complex issue involving state and federal law, constitutional violations, and private property takings. Elements of the compact result in the abrogation of state and federal responsibilities to citizens. The issues presented with the CSKT Compact must be fought on multiple fronts and at multiple levels, and include property takings, constitutional violations, and potentially action for deprivation of civil rights, including violations of the equal protection, due process, and other rights of citizens, brought on by the Grand Bargain and the Unitary Management Ordinance. Eternal vigilance is required. The Montana congressional delegation is already using the CSKT Compact assumptions to expand reservations, treaties, and tribal jurisdiction in lands. Senate 3013 is an expanded version of the CSKT Compact. Senate 3014 designates national forests and public rangelands as tribal forests and rangelands, and Senate 2938 involves energy resource royalties. The impacts of the CSKT Compact on Western states is potentially significant. As shown in this map, the extent of Aboriginal or historic former reservation lands of the tribes is huge in the United States. If the CSKT Compact is allowed to set precedent, tribes across the United States will begin to seek not only water rights off their reservations, but managerial control over lands and water resources. In combination with federal legislation aimed at providing a seat at the table for tribes in decision-making authority over the management, development, and disposition of federal lands, the groundwork is laid for the disruption of state institutions, land use, and economies by a special class of citizens in violation of the rights of the majority of citizens residing in Western states. For example, Senate Bill 3014, sponsored by Montana Senator Steve Daines, proposes to redesignate all national forests and rangelands as tribal forests and rangelands for the purpose of carrying out planning and management activities on these lands. These newly redesignated federal lands, now designated as tribal forests and rangelands, propose to include previously ceded lands, judicially determined tribal homelands, as shown in this map, all lands covered by a federal reserved water rights settlement, and current or former reservation lands. This is a gross federal overreach and a clear threat to the states. Thank you for reviewing this video presentation. The Montana Land and Water Alliance certainly welcomes your thoughts and assistance in the issues presented here. Please contact us for further information.